Councillor Kelly, Councillor Kitt, Councillor Leddy, Councillor Maguire, Councillor McCamley, Councillor McDonough,
Here.
Councillor Mulligan,
Here.
Councillor Mulville, Councillor Murphy, Councillor Newman, Councillor O'Brien, Councillor O'Donoghue, Councillor O'Leary, Councillor Onyemera, Councillor Quinlan, Councillor Quinn, Councillor Ryan, Councillor Sheehan, Councillor Shovlin, Councillor Thormy, Councillor Troy, and apologies, Councillor Walsh.
Council meeting Monday the 11th of November, 5 p.m. All mobile phones should be on silent or switched off for the duration of the meeting. Please note that this meeting is being webcast. All members, please remember to switch off your microphone when you've finished speaking. All members are reminded that the chamber is a non-smoking vaping area. Standing orders will apply to all aspects of the meeting. Councillors are reminded of the provisions of Standing Order number 92, that all members are bound to act in accordance with the ethics framework and code of conduct for the local authority members to cooperate with the orderly conduct of meetings, the direction of the Mayor and in a manner that is respectful of colleagues. Members have been circulated with the agenda for today's meeting, and any member forming the view that they have a conflict of interest in the matters subject to today's agenda should now disclose the same. Councillors are also reminded of the provisions of Standing Order number 93 that members must bear in mind that discussions at council meetings are not privileged. No member may make false statements, impute improper motives, or use offensive and unbecoming words in reference to any member of the council, employee of the council, or any other person. Any member having made such statements or used such objectionable words and not explaining or retracting the same or offering apologies for the use thereof when requested by the Mayor to do so shall be called upon by the Mayor to withdraw from the meeting. Members making any such statements or comments may find themselves personally liable for them. Number one, confirmation, reaffirmation of the minutes of council meeting held on Monday the 14th of October 2024. Proposed? Seconded, Councillor McCamley. Questions 2 to 20. A proposer? Proposed, Councillor Tormey. Seconded, Councillor McCamley. Report, 21, report of committees. We have 21A, report of corporate policy group meeting held on Monday the 4th November 2024. Under the corporate policy group meeting, I want to raise the issue in relation to the an update of the legal case regarding the DAA, and I know the Chief Executive wants to give an update on the issues or what has happened in court and where we are at the moment. Chief Executive.
Members, there were two recent judgments, and the most relevant judgment to the Council relates to the zoning of the ALSA lands. That case was ruled on as outlined in the document on the screen on the 17th of October. The judgment means that the zoning of the councillors was not accepted by the judge, and he has deemed that the lands should be dezoned, which effectively means that the lands are now unzoned, and any future zoning will require a decision of this council. I don't recommend that a leave to appeal be sought, and the leave to appeal would involve an application for leave to appeal to the Court of Appeal, and if necessary, an application for leave to appeal to the Supreme Court. Just to say that the matter stands adjourned until next Monday, and before that time we will need to notify DAA as to whether of our intentions to appeal or not. I'm recommending that we don't appeal on the basis that the future zoning of the land will require a decision of this council, and ultimately the judgment in the case relates to the zoning of the land, and I'm looking for your agreement to that position. Under Section 1532 of the Local Government Act 2001, you'll remember back in July, authorisation of the elected members was given to me for the legal proceedings in this case, and I'd look for that to continue in relation to any appeal if there was such a one. So I'm looking for an agreement to the proposal that leave to appeal is not sought.
Councillor Healy.
Good morning, and thanks to the Chief Executive for that. I certainly would be sympathetic to that recommendation. My real question is that my reading of the judgment is that there's nothing in it which would constrain us in our future rezoning decision if we would come to it, but I'd be grateful if the Chief Executive could confirm that that's her interpretation as well. Thank you.
Councillor Humphreys.
Similar to what Councillor Healy just said, rather what our final judgment came, he didn't find any issue with, it's just how we came to it. Is there a possibility of seeking an adjournment to allow this chamber to take a bit more time to consider if we want to appeal, as especially as we're facing another development plan, and this the executive were very clear every time we strayed off course to bring us back into line on what our legal requirements were. My opinion was that the judge was probably a bit harsh on, especially on of us who, the majority of us, aren't legally trained, and for future development plans, I'd be more fearful of setting a precedent that how stringent and how careful, especially in the cuts and throws of a discussion that we'd have during the development plan, that this will be the standard that we'll be held to going forward. I just have kind of apprehensions about a precedent being set on how stringent we can be during a debate, and the very fact that during this debate, when we did go off course, we were corrected by the executive and brought back on course. I just have apprehensions about not appealing and allowing this to be the new standard.
Councillor Kieran.
Yeah, I think it would be a pity not to appeal, and I fully respect the comments of the Chief Executive. The reality of this is that 39 members voted unanimously in favour of a motion. What this judgment does is put it back into the council executive. Will have to bring a variation, I presume, but to vote that land CI a second time would have its own legal implications, because it could be interpreted that the court said CI was not the appropriate judgment. And I do believe, I know in judicial reviews the court doesn't have to list answers to every question, but the fact that they didn't address some of the opening questions in their judgment does leave grounds for an appeal to be sought, which would likely, whether it would succeed or not is irrelevant. But it's relevant, but you certainly will get leave to appeal on that basis. I'm also concerned that 11 members were cited in the judgment as being the responsible parties for the case succeeding, and the judge has assumed that we can't make comments about our community and their wishes and then vote properly when it comes to planning rationale. So I think, you know, it's certainly lessons to be learnt. There's no doubt, but it's a slap in the face for democracy, and there's no doubt that this will give way to what the real intentions of the DAA may or may not have been when they put in their proposals at the time of the development plan. I think for the interests of local democracy, and particularly in relation to decisions that this council might make going forward in relation to other matters, I think we should look and see if there is a possibility to appeal. You know, there was a debate on Cherryhound that lasted 55 minutes. There was 29 minutes of contributions from the executive. There were things said there that one could say is personal, but we leave the jersey in here when debates are over. But I think for a court to assume we can't discuss the needs of our community and then make a proper planning decision or vote with planning rationale, I think is an assumption that's dangerous, and it sets a dangerous precedent. So I would think we should take more time before we make a decision on this. Thanks.
Councillor O'Leary.
Thank you. Could you clarify, the lands are unzoned, it's a fact, so what's the process? So how would they be appropriately zoned by the members' vote? And could that be back to the original zoning that was there before the members' vote, you know, that we're discussing here, or to CI as the members voted? So, and how might that happen? Who leads out on that? Do we put down motions? Do the management put down motions? Variations, whatever the term is. How does that happen? So if we're not going to appeal it, have the members the full right to do it properly this time, quote unquote, whatever that is, and zone at CI.
Councillor Mulligan.
Thanks. Yeah, it's very disappointing regards to court's judgment, but I do think it points to the very difficult nature of what a development plan is and the amount of hours that councillors put in, but also the real lack of knowledge around the national planning framework, the ministerial guidelines and the regional spatial economic strategy that we as councillors have, because we're not given that intrinsic training around the actual plans that would require us to know that you can't, although you can mention a land use objective, mentioning a business which currently resides on a land use is contrary to proper planning, because that business isn't subject to a zoning at here and now when you're zoning land. So it's the use of language might be considered by the judge as inappropriate, but with respect to the actual use of the site and the land use zoning, it was done in the right context. And I suppose if we as councillors are not trained or not given proper advice in which to discuss and have these conversations in a live forum when we're zoning land, as Councillor Guerin said, I'd be worried about the implications on opening the floodgates to more judicial reviews in the throes of an 8 or 9 hour meeting where, you know, you're tired and lethargic and trying to get your point across on a motion that's 50 down the line, and you might say something at a slip of the tongue and mention something on a subject land site, and all you're meant to say is about the use zoning objective. And I just think it's fairly unfair to bestow such a judgment given the context of the overall plan and how prudent and how many hours we put in. But I understand the law is within the law. But yeah, I'm glad we're having the conversation today about it. Thank you.
Councillor Butler.
Yeah, I suppose my concern here is, you know, adjournments and appeals all cost money. So I'd be kind of agreeing with the Chief Executive that we leave this, the land's unzoned, it'll come back to us. Yeah, just as I said, money's gone into this already. Any appeals, any adjournments, etc. We're spending taxpayers' money, and I'm not sure there's a good reason to in this case. The way it's been left at the moment, and it seems to be coming back to us in our remit what to do with the lands or how to zone the lands. Thank you.
Councillor Graves.
Yeah, look, I have a major concern with this. I mean, we have had the powers of elected representatives diminished and eroded over the last number of years. One of the things that we do have charge of is the development plan. This motion was unanimously agreed. We also had another, we had a ministerial order which changed another part of our development plan. And, you know, this is one of the things that we do have control over. And it's strange to me that both of the changes to the development plan relate to the DAA lands. Now, we met the members of the Forum and the St Margaret's Award group before this, and one of their major concerns are, you know, lack of enforcement, the time it's taken, you know, for Fingal County Council in particular to go after the DAA where they are breaking the rules. I actually think that we should fight this because it's not clear-cut, and certainly if it comes to a vote, I'll be supporting appealing. Thanks.
Councillor Newman.
Thanks, sir. Yeah, look, as one of the people that was mentioned in the judgment, I don't really have huge issues on that because, look, it's a person making a judgment based on the information he had or she had. Doesn't mean it was right at the end of the day. And the irrelevant non-planning considerations, were they all everything irrelevant, or was it just some? And if it was just some, why weren't the valid ones taken into consideration? We had, I think we need independent legal opinions available to members for the next development plan, so as when there's any issues that maybe the executive brings up, and the advice that they do give us and their opinions, which is valid in most cases, that we can get clarification and move on from that. I just feel that any members, well, we had, you know, the majority of people that was at the meeting, all of the people at the meeting, I think, agreed with the submissions and proposals. I'm just saying that if they had any concerns about it at that point in time, like they might have now, that they should have voiced their opinion through a vote, and by not agreeing with what the proposal was or the motion was at that time. So we have an obligation on ourselves to ensure that we just don't, you know, let something go through because it's probably maybe a reason for it at that time. But the thing is that if you're not happy with it, say what you feel and make your voice known then. Thanks.
So the manager has proposed that this is their intended course of action. If anybody wants to do anything different, I would suggest now would be a good time to put a motion down to put a motion down accordingly. Oh, sorry, work away. Sorry. Executive in, apologies.
Members, just a couple of things there. I think Councillor Humphreys asked the issue about more time. A second adjournment has been given. It seems, I would say, that there's a reluctance on behalf of the court to grant a further adjournment, but it certainly could be asked for. But in terms of what I understand is happening in court, they want the matter settled as quickly as possible. In relation to the appeal and the purpose of the appeal and the likely outcome of the appeal, in any event, it's likely to come back to the Chamber in terms of deciding the future zoning of the land. So it's on that basis, I'm saying, on the basis of the judgment, that the land is now effectively unzoned, and the zoning of land is a matter of the planning authority and for the council. I'm suggesting that there's probably little benefit in appealing the case, because ultimately the decision rests with the council in any event. On the zoning itself, I think we should only speak about appeal or not appeal today, because I think the decisions in relation to future zoning will be subject to a separate process, and I'll ask Mr. McAleese to come in on the process associated with that. In terms of there being only 2 judgments and them relating to DAA, that's just a coincidence of events. There are further development plan cases underway, and they'll be decided in due course in 2025, I expect, and we wait the outcome of those. In relation to proper planning and sustainable development and the recommendations from the planning department and from the senior planner at the meetings, I think it's regularly stated by the planning professional staff that only proper planning and sustainable development can inform decisions. So we certainly can look at that in the next development plan just to make sure that everybody understands that. But I think, in fairness to councillors, you had a good understanding of that position, and you made a strong development plan. The fact that 1 or 2 court cases may rule against us does not signify that you weren't aware of your role, and certainly in my view, you prepared and put in place a strong development plan for this county with the proper considerations informing that. and then it is not insignificant, the cost of taking appeals and the value of taking appeals, both in terms of financial and staff resources. So you need to understand how you might benefit from the appeal, successful or not. And on that basis, again, I'd be recommending that there's not enough in this case to benefit us in terms of taking that appeal, albeit that's, it may provide further clarity on some points. I don't know whether it would or wouldn't. To Councillor Gearan's case about points of law, I wouldn't be able to comment as to what point of law it should be appealed on. Presently, there are none identified, but that would be a further piece of work by the legal advisors to determine what points of law the case could be appealed on. I'll ask Mr. McAleese to come in on the separate land use zoning piece.
Thanks, Chief Executive. So just in terms of the variation process itself, the elected members may at any time for stated reasons submit a resolution to the Chief Executive requesting that he or she prepares a report on a proposal by the members to initiate a process to consider a variation of the development plan in force. However, it would be our intention that we would bring forward a variation before yourselves, which we can also do. So what that variation would look like and the timing of that haven't been decided yet. Obviously, look, we have to consider the judgment in more detail. Just on Councillor Healy's query there, I just bring to your attention the case note that was circulated to yourselves there, and in the summary part of that, it does state that the court accepted that the existing use was a valid planning consideration, but considered that some comments, and I'm quoting, some comments place reliance on supporting a particular occupier and supporting that occupier in its dispute with the DAA. So just to point out that, the change to CI zoning was considered to be a valid planning consideration, and can be considered again in any variation that would be brought back before use at a later date.
Councillor Newman.
Just a point of clarity, Mr. McAleese. Did you say it was the occupier, DAA, or was it ALSA was the occupier?
Just to quote again, some comments place reliance on supporting a particular occupier and supporting that occupier in its dispute with the DAA.
Thank you.
Councillor Gearan.
Yeah, just if just if the Chief Executive could clarify for us that if we don't appeal this and the order is perfected, does that mean that the order could then be used against us in other ongoing cases where people to take out videos of various development plan meetings and look for contributions which could be deemed to be made, not taking just planning rationale? That's the first thing I'd say to you. Secondly, if we could get an update on what transpired at today's adjournment, and is it adjourned again, and did the court allow it, for what reason did we seek the adjournment? And the last thing I make is I wouldn't dare come in and make a comment in relation to a legal point as to why something could be appealed without having sought the legal advice. And that advice was made available to me over the weekend and again in an opinion today. So I just think that for the sake of democracy, for the sake of this chamber, if we're going to let the cost get in the way of the power of local government, I don't know if that's really a good enough reason. Let's not fight something because it's going to cost us X. I think the principle is more important. If members don't agree, that's fine, and I fully respect that. Thanks.
As it stands, the Chief Executive has the authority is delegated. Sorry, Chief Executive.
Members, the council sought an adjournment this morning because the council meeting was this evening, so to give the time for the matter to be considered today by the council. In relation to the webcast of any meeting, this or a development plan meeting, the webcast does exist and is available to third parties to use I suppose, as a fact of what was said at a meeting, albeit that the minutes of a council meeting is always the formal record of the meeting. This is a standalone case in terms of how it establishes case law for other proceedings would be a matter for the courts in the future. But the judgment of the case relates to the zoning of the land as opposed to what informed the judgment. But yeah, absolutely, it is a case. The judgment is, if perfected, will be a matter of public record. How it would be used to facilitate other cases, I simply don't know. However, the judgment relates to the zoning of the land, and it's on that basis that we're recommending no appeal is sought. Apologies, Councillor Guerin. It's adjourned for 1 week until next Monday, which is the 18th of November.
Okay, so we'll move on then to report of the committee item B, report of the House Malahide. What's in? Sorry, so we're just clarifying in terms of I want to be very careful in relation to the motion to make sure that it's technically correct, so that if it were passed, if it's incorrect, we don't want to cause any issue. So the Chief Executive believes that perhaps you could amend it.
It's just a slight issue with wording. I think what the councillor may mean is that that section 1532 would apply, which would be that the executive would act on the council's instructions and deal with the appeal on that basis. So it's the authorisation under 1532.
Councillor Coppinger, yeah.
So the issue is that if this decision is definitely in our hands to decide the zoning, I mean, my only hesitation about the motion is the costs, public money. I'm sure that's on a lot of people's minds. It can run into tens of thousands in appealing it. So it would be only on the basis that we're assured that it is coming back to the council for our full decision, because I would obviously be very concerned to keep it in community, hands as well. So is that being assured before we vote?
My understanding that's clear in the judgment, that it requires a variation and that a variation is agreed and conducted by the council. And it is within the judgment that, as was stated by Mr. McAleese, that the change that that zoning for community infrastructure is a reasonable planning objective, but that nobody should have discussed who a particular occupier was, or the fact that there was a dispute which was separate. So as long as the same error, that there's just a planning rationale debate, well then that should be fine. I'm going to need an amendment, or it's there, perfect, it's in amended. So that's proposed by Councillor Grays, Councillor Quinn, Councillor Hanafy, Councillor Donnelly. Councillor Graves?
And that's stated, and the fact that we discussed other issues around it, shouldn't be a reason for squashing the zoning decision. This is our development plan. We made a decision unanimously, so that's really the point of the motion.
Councillor Gearan.
Just in relation to the motion, I support the motion. I would just be fearful that a judgment, if perfected and not appealed, is then established and can be used against us in subsequent cases, and indeed can be used against us in subsequent development plans. So I think that that's something that we should be very much aware of. And I think it's the members' contributions were not the only reasons. So I really think before we try and rezone the land, if we were to do it in a particular manner that the court found wasn't suitable, we are open to risk of that being challenged and overturned again. So I'd certainly be in support of the motion, and I think for the sake of local democracy, for the sake of future development plans, for the sake of not trying to restrict members making genuine contributions, I think it's important that the decision be challenged. Thank you.
Councillor Healy.
Yeah, thanks, Chair. Chair, I don't think, having read it, I don't think it's necessary for us to appeal this. I don't think Councillor Gearan's and other people's concerns are unreasonable, but I don't think that they're really something that we really need to take into account to the degree that we should go off incurring the costs and the effort of appealing this. It's quite clear from the judgment that we can put a community infrastructure zoning if we wish to, and if we have the valid planning reasons and rationale behind that decision when it comes to it. So I don't think we're going to achieve anything by another adventure in the courts. Thank you.
Councillor O'Brien.
Yeah, thanks, Mayor. I think Councillor Healy put it better than I could. We can revisit this through the process that's available to us without having to go down the road of an appeal that we're probably not going to win. But as I said, Councillor Healy put it better than I could. So that's the reason I'll be voting against this motion if the Sinn Féin group push it to a vote. Thanks.
Councillor Dennison.
Mayor, I'm opposing this as well. I think in order to make an appeal, we have to have grounds to make an appeal. And I understand there are no grounds for making an appeal. And it would be just throwing good money after bad, because it's already cost us a good deal of money. We were within our rights to make a development plan, but the courts found that the way we made this was wrong, and it's going to remain wrong, even under appeal. So we better get it right next time.
Councillor Mulville.
Thanks, Chair. I wonder, I'm just reflecting on when people come to me about advice, potentially going into courts or going legal routes, they often suggest them to try mediation first. I don't know, is there space for mediation before getting into lengthy, costly court battles, you know? Is that something we could be advised on? But also I think, given that we have until Monday to make the decision, I mean, that's quite a detailed judgment from Justice Humphreys. Is there space to have a briefing for councillors to take us through that judgment in more detail so we can kind of understand it a bit better, exactly what the ins and outs of it are, before, as I say, we have to make the final call on this before Monday. Thanks.
Just before any of that question is answered, this is on a judgment that has been made by the judge, so my assumption is mediation happens before you get to court or as a part of that process. So what we're appealing is the judgment of the judge, and that can only be done by a legal case. There's no room for mediation, because even if the other side were to accede to it, the judge is still the one who made his decision in the court. And then later I'll bring the manager on the question of briefing or otherwise. Councillor Newman.
Yeah, thanks, Mayor. Look, I've kind of changed my mind at how I felt in the initial stages about this. The judge, I think there's, probably a case to appeal the decision to get some clarification. One, on what's an irrelevant non-planning, consideration. What exactly is that? To select a number of people and put their names on the court case on record is probably another thing that could be questioned, and to see was that something that is normal and acceptable. And You know, to mention an occupier as like Alsa, as the case I did, and then they're saying I mentioned the name of the occupier, you know, it's I don't know if it's the name of an occupier, but it is the organisation that's there. So if we were just to say the occupier rather than mention Alsa, would that be acceptable in court? Thank you.
Councillor Gearan.
I apologise, just in relation to Councillor Dennison's comment, because very important. Have we received legal advice that there are no grounds for appeal? Thanks.
Councillor Humphreys.
Right, literally what I was about to ask. As I'm inclined to support the motion, I do think there's a principle there to be fought on. I don't know if this is the case for it. It's already been adjourned twice now. The Chief Executive has indicated that it's unlikely to get adjourned a third time. Now we're asking you to, within a week's time, find a reason to make to build your case on and then present it. I just would I be correct in that you don't think there's any grounds for an appeal, and that we're asking you to find grounds in appeal and to present a case within a week's time because you don't think there will be another adjournment? Would I be correct in that assessment?
Councillor McCamley.
I just want to ask a question to Mr. McAleese, really, and maybe I should know this, but if that land is not zoned now, do we go then for a variation to zone it, or do we wait till the next development plan to zone it, or how long? If it is a variation, how long would that be? Because I'm a bit worried about the land not being zoned at all.
So I'll ask Mr. McAleese to come in first, and then Chief Executive.
We wouldn't wait until the next development plan. We would be bringing a variation forward as quickly as we could. Obviously, there are a number of other development plan judicial reviews that are in play at the minute, so we would probably just wait the outcome of those. They may result in other variations potentially as well, but we would probably be looking to bring a variation to you next year.
I don't think it's wise to discuss hypothetically whether there's grounds or not grounds on this case, because ultimately we're in another legal case should this motion be passed. So therefore, if the motion is passed, the legal team would have to be instructed to review the case and determine if there are grounds to appeal. But I don't want to get into hypothetical grounds or speculative discussion on whether there's grounds or not. My advice is based on the fact that the lands are unzoned, and that the decision to zone the lands in the future is with the council, that it will take resources to appeal the case, and it does seem like a difficult task in the context of this case to yield an outcome that justifies taking the appeal, which may be slightly different to the way councillors are thinking, or some councillors are thinking. So my recommendation remains the same, that I don't see the value in making this appeal. And as Mr. McAleese has outlined, this and there are some other lands that are currently unzoned that will be the subject of future decisions by the planning authority, which is yourselves. So if you bear with me, I just literally feel it does not make sense to me to discuss the grounds of appeal in a public council meeting when you're talking about taking another process against an entity. So I'll leave it to you. Certainly, if the motion is passed, we would instruct the legal team to look at what the grounds of appeal would be and the points of law involved.
Councillor Burchell.
Point that the DAA is in breach of legislation itself, but it's very quick to run to the courts to, quash efforts to serve the community. So it's not an entity that I have very much sympathy for, And on those grounds, I'd be inclined to support this motion.
Councillor Graves.
Yeah, look, you know, I do appreciate the advice from the Chief Executive and Matthew. But what the Chief Executive said is the decision to zone the lands will be made by the councillors. The decision to zone the lands was made by the councillors. And this is why, you know, we are where we are, you know. So I can't kind of preempt what the future will hold, but if there's another case, if we decide to go for the same zoning, who's to say there won't be another case and we'll end up back in the same place? You know, I'll be calling for a vote on this unless the motion is agreed. Thanks.
Well, 3 minutes, yeah.